I think the odds are that the court will uphold the law. I think the court's precedent largely supports what Congress did. In recent years, the Supreme Court has said that if there's an economic activity, then the court will be very deferential to Congress in regulating that economic activity under the Interstate Commerce Clause. So the question becomes whether or not the purchase of health care insurance is an economic activity. I think the court is likely to think that it is, and therefore find that this regulation would pass its very deferential test. In order for the court to strike this law down, it would have to find that the underlying activity, the purchase of health care insurance, is not on some level an economic activity. I think we ought to be very careful not to confuse the political rhetoric with the case with the legal arguments. So politically, a lot of people want to make this case to be about something that they'll describe in the most extreme terms. And that gets attention, but I don't think that has anything to do with the law. And so the political rhetoric is designed to get attention and to perhaps raise interest in maybe the stakes in the case, but I don't think it's necessarily going to persuade justices. So the justices who are uncertain would be Kennedy, Roberts probably, and Scalia, and maybe Alito, and those are the ones to watch. If you look at some prior decisions that occurred of late, Chief Justice Roberts has been in the majority in upholding a broad Commerce Clause power, and that gives you some reason to think he might join this as well.